Hi and welcome back to another video on criminal law. We're going to be looking at attempts today under the OCR law specification. The first thing to remember with attempts is it is defined in statute law. So the Criminal Attempts Act 1981 section 1 sets out the definition of an attempt. One of the classic errors people make when looking at attempts is they try and combine the current law of whatever the offence being attempted is. So quite often people will talk for instance, about attempted GBH and start trying to bring in the words wounding or inflicting and things like that. And of course, that's actually completely irrelevant. The Actus reus mens rea for any attempt is more or less exactly the same based around what I'm about to show you. So you don't need to go into the ins and outs of that particular offence that's being attempted. So sort of treat them as completely separate topics, essentially. Now, we know an attempt is where you try and do something. We can see that really clearly from a case called White, although White didn't provide the definition that we use today. Remember, it's the Criminal Attempts Act 1981 that provides the definition. In White, for instance, he poisoned his mum, but before she drank the poison, she had a heart attack. So he attempted to murder her. Clearly, he tried to do the offence, but in some fashion failed. Attempts is a really big, important area of law. Obviously, there's a big debate around whether someone should be criminalised or prosecuted in the same way for an attempt because they haven't actually achieved it. But for this topic, there is no essay required. So we're going to focus purely on the facts, the content, and then how to look at a scenario on this. So if we do look at the Criminal Attempts Act, the Actus reus mens rea really clearly set out here. And the Actus reus, the thing you actually have to do is doing an act that is more than merely preparatory to the commission of the full offence, which means you've done something that's more than merely preparing to do the offence of whatever it is. The mens rea is intention to do the full offence. So no mention of recklessness there, and I'll come to that in a minute. It's purely intention to do the full offence. The category and maximum sentence will depend on the offence being attempted. So you don't need to worry about that in terms of huge detail. Now, if we look at the Actus reus and what more than merely preparatory means, you can see here I've split it into cases that were defined as merely preparatory and therefore not an attempt on the left there, and cases that were more than merely preparatory, so they were an attempt on the right. So if we start at the left-hand side, the ones that were not attempts, in Gulliver, he put some money on a dog race, he jumped down to try and stop the race, and then left the stadium or left the place at that point. And they said that was merely preparatory for an attempted theft because he'd have to have actually gone and tried to get his money back for it to be an attempted theft. So they said that wasn't. He was merely preparing there. It didn't become an attempt. Campbell, he was found outside a post office with a fake gun and a threatening note. And they again said it was merely preparatory. It wasn't more than merely preparatory. They said for it to be more than merely preparatory in an attempted robbery or something like that, he'd have to have actually gone into the post office. Geddes is a bit of a weird one. He was found in a toilet in a school, didn't work there or anything like that. He was found with duct tape, a rope and knife, etc. And obviously it was around sort of attempted kidnapping. And they said he was merely preparing, again, shockingly really, but they did, because they said he had to have actually approached a child. So there is a sort of a theme going through there. They have to have done like another step yet for it to be an attempt in all three of those really. If we look at cases that are more than merely preparatory, you've got Jones, for instance, where the defendant got into the car with the victim and pointed the gun with the motorcycle helmet and pointed the shotgun at him. And they said that was more than merely preparatory for attempted murder. The defendant in that case tried to argue that there was a safety catch on the gun. That would have been the last sort of step in terms of preparing. And they said, no, that's not. They said getting in, that was enough, and pointing the gun at him. Didn't have to fire the gun or anything like that. It was more than merely preparatory and therefore an attempt. Agee's reference, a bit of an unpleasant case. It was a defendant trying to rape a woman, but he couldn't get an erection. So they said that was, more than merely preparatory. It was, he'd gone beyond preparing. And that was really a public policy case. They never really have said that that was just preparatory. That certainly wouldn't have been fair or the right thing to do. Tosti and White's a bit of a strange one, again, in terms of really, it did seem like they were preparing. So they were found outside a house or sort of a building observing the locks. And there was their cutting equipment in the hedge down the road. And they said that was more than merely preparing. So again, seems a bit weird. Seems like they were preparing perhaps, but the court very clearly said it was more than merely preparatory. So it's not always easy to tell sort of whether something is more than merely preparatory or merely preparatory. You've kind of got to go with the gut feeling, and in the exam try and use some sort of case reference to try and back up why you're saying that particular route or avenue really. In terms of the mens rea, you have to have intention to do the full offence. You can see that very clearly in Wybrow. He wired up a soap dish to injure or sort of harm his wife. He was charged with attempted murder. He couldn't be guilty of that because he didn't intend to kill. So it has to be, for attempted murder, it has to be intention to kill, the intention to do the full offence. So it's really important that Millard and Vernon showed that very clearly recklessness is not sufficient. So Millard and Vernon, they were just shaking the two lads, very young, shaking this fence, and they were charged with attempting criminal damage, and they weren't intending to do criminal damage. They knew there was a risk maybe and decided to do it, which is the definition of recklessness from Cunningham, but they certainly didn't intend to do it. So they said they can't be guilty of attempted criminal damage in that case. So recklessness is not sufficient. It's got to be intention to do the full offence. And you'll need to look at that in the scenario from sort of the facts and what the person's doing as to whether that demonstrates intention or perhaps their behaviour and things like that. A couple of last bits on this in terms of relevant cases and areas that could come up. Attempting the impossible is a really important bit. I've shortened this right down. There is some important bits around attempting the impossible within the Criminal Attempts Act as well, but if you keep it simple, there's two main cases on it. Shipuri, which overruled a previous case called Anderton v Ryan. Shipuri was caught trying to smuggle what he thought was drugs into the country. It turned out to be powdered cauliflower and other bits. The issue was whether he could be charged with attempting something that was actually impossible. It wasn't possible for him. He didn't actually smuggle drugs in. So he couldn't be attempting that because it wasn't drugs. But they said, actually, in fact, you can be guilty of attempting the impossible. And that is a really popular bit that comes up in the exam. So really make sure you understand the issues around attempting the impossible. Have a read of Shipuri in any textbooks or online and see if you make sure you understand it. Jones, very similar case in terms of attempting the impossible as well. He was grooming an underage girl who actually turned out to be a police officer, and he said, well, I can't be guilty of attempting this because it actually isn't an underage girl. And they said, no, you are guilty of attempting the impossible still. So some clear public policy issues around that, particularly that last one. So remember, public policy is doing what's in the best interest of the public. Conditional intent, this is something that people get really wrong because they really focus on ESOM. ESOM, basically, it was a guy in a cinema, he reached into a lady's handbag, couldn't find anything he wanted, so took his hand out. And they said that couldn't be attempted theft because he didn't intend to steal anything specific. That's been overruled now by AG's reference. And AG's reference says very clearly that conditional intent is okay. So what that means is if you put your hand in, not intending, you go somewhere not intending to do anything specific, but you're going to take something on the condition that there is something, then that's fine. That is sufficient to be the mens rea. So, in cases like ESOM, would be guilty now. So you've got to be really clear though that that's, ESOM's been overruled by AG's reference, and that's the law today. In terms of a scenario, like I said, there is no essay, so you don't need to learn AO3 for this. It can come up by itself, or it could in theory be combined with another topic like murder or non-fatal offences. So you might have, one murder and one attempted murder, or a couple of non-fatals and attempted non-fatal. So just be clear when you're doing that, not to try and combine the law, like I said at the beginning. Like attempts is a separate area. You can forget the mens rea and actus reus of murder or non-fatal when you're looking at it. Purely focus on the Criminal Attempts Act and the merely preparatory formula and the mens rea around that intention to do the full offence and things like that. So treat them separately. You could just get an attempt, like I said, by itself, in which case there's likely to be 2 or 3 different attempts, perhaps, equally with issues around sort of attempting the impossible or conditional intent, things like that. So you can see down the bottom there, it's really important that you apply the actus reus and mens rea methodically. So you're going through really clearly, like, why is there an act that's more than merely preparatory in the scenario? And what's the defendant done to be that? Did they have intention to do the full offence? And yes or no, and why? And then making sure you cover anything relevant like attempting the impossible, conditional intent, if it is relevant. Okay, so that's attempts. Like I said, there's no essay on that, so I hope you found that useful. And subscribe to this channel for more videos, and more will be coming up soon. Thank you very much.